So today's topic, we're kind of calling it the trademark playbook, how to register, monitor, and enforce trademarks in a global economy. One of the challenges that we see a lot of our clients have is that, registering a trademark in the US, okay, that's kind of basic 101 stuff, but then what? Like, what do you do when it comes to all the international considerations that a company might have these days, all the work it might be doing outside of the United States? And then how do you actually handle and monitor and enforce all of those trademarks? So we're going to go through that. Um, there we go. A little bit of background about us in case you haven't been to one of these before. Our law firm's in our 17th year, about to be 18. We currently have 7 lawyers, 4 paralegals. We're spread out a little bit. We're a fully remote law firm. Eric's coming to you live today from Bethesda, Maryland. Recently defected from District of Columbia, and I am up in Pennsylvania outside Philadelphia. So we have other people kind of scattered throughout the East Coast. A little bit of background about us. All we do is trademark work. So we have registered over 8,000 trademarks over the last 17 years. In the United States, we also help clients register trademarks in other countries. So over 30 countries around the world, we've got trademarks that we've registered and help our clients maintain and enforce. We settle a lot of trademark disputes without litigation. We really take our pride in helping our clients avoid court when possible. We can also handle litigation. We've got a number of cases in federal court, and we deal with hundreds of cases at the Trademark Trial and Appeal Board, which is the administrative court at the USPTO. We overcome a lot of office action refusals for our clients. So a lot of people run into trouble during the application process. That's something we handle. And then just last year, we did register 833 trademarks for clients. So just to give you an idea of the scope of our trademark practice. So today's presentation, just to walk you through kind of what we're going to talk about. The first thing, even though this is an internationally focused presentation, we want to start talking about US trademarks and what's important to register, because if we're coming at this from a US centric approach, so we're assuming that your client or the people or the folks that are here, you're starting in the US and then registering elsewhere. So that's sort of the approach we're going to take. But we got to talk about what's going on in the US before we even talk about international. Then we'll get into obviously the big one, which is the international trademark filing strategy and how that works. We'll talk a little bit about monitoring and enforcement of trademarks, and then ultimately how to maintain a portfolio, meaning typically renewals and other things you need to think about there. So just to kick us off, in case, again, you haven't been here before, but what is a trademark at its bottom line? It's a source identifier, meaning that if you see a trademark, like you see a Nike or you see a Kodak or you see a Pepsi, it lets you know what company you're buying a product from. So it's identifying the source of the company. Trademarks take on a lot of different, it can be a lot of different things. Basically, I mean, we all know that a business name, a logo, a slogan, sometimes colors can be protected as a trademark. A sound, you think of Netflix and ta-dum when you turn on a Netflix and it loads, that's actually a registered trademark, that sound. So a lot of different things can be trademarks if they help a customer, if a customer sees, hears, even smells something, and will understand that that is indicative of a particular product or service coming from a specific company. This is just a quick, good example of, something that might give you a little bit of a craving here, but you've got Oreo, we could protect the name, different product and service, product lines or service lines you might have. So again, they have a Thins product line that is protected. Slogans, obviously a logo. This is a trade dress. So Oreo's got protection over the look and feel, or the look of the cookie. There's a very distinct design on the top of an Oreo cookie that people might recognize and say, hey, I know I'm eating an Oreo because I'm looking at this design. So,
and also, Josh, that's not even, and so even just kind of to tie it into the international perspective, these words, what we call trade dress might not even be called that in other countries that may respect it in a different way. Like industrial design is a word you'll see. So I think even as we describe kind of the basics of what a trademark is, we're still taking this kind of US centric approach, which I think is really what our first topic is on. But sorry, I realize that's the next slide, but yeah, I just thought that was important to note, is that there are every country is going to have their own set of trademark laws, and they're each going to be slightly different in ways that show in very strange and different ways. And so when it comes down to US trademark strategies, it really comes down to protecting it in the US first, because I think that's going to be where you're going to build from. That's going to be the base of your tree, and then you're going to branch out from there. But I realize I'm jumping ahead a little bit.
No, I mean that segues right into it. I'll turn the floor over, but yeah, like you said, I mean, you have to protect your brand in the United States. That's typically going to be first and foremost, unless you're obviously starting from outside the U.S. And Eric, if you want to talk a little bit about that, here's just some things that we talk about to clients about when we're starting the
Yeah.
trademark protection journey.
Yeah, I think that when it comes to trademark protection, I'm going to say something slightly controversial, that if you are a US company, your primary business is going to be in the US. If you can't protect it in the US, it does not matter if you can protect it in 300 other countries. It is primary, everything is going to start with the rights you're able to protect in the US. And even a lot of non-US companies, they see the US as kind of the golden trademark registration, that if you can get it in the US, that's going to really cover a massive amount of the protection that's needed, because we have one of the strongest trademark registries in the world. A lot of other countries don't do the same rigor of examination that the US does. And so there's strategies involved in that, but it is something that I think is really important to start with that. And then, the question kind of from a very broad perspective is, where do you start? I always think of it as a kind of top-down approach. Make sure that you are identifying what's going to be on every product. A lot of people get distracted by a fancy slogan or by packaging they really like, and then they forget, well, I got to protect the product name, the company name that's going to appear on all those product packaging. If it's a service, what's going to appear on the header of the website. Those are the kind of things that we're constantly looking for, and I think there is a priority there, starting at the thing that's everywhere and then getting down into the more specific ones, and then you get into like trade dress and things like that. And then also covering the enough goods and services. This is actually going to be a huge difference from other countries around the world. In the US, we really encourage clients to focus on the core goods and services that they're providing, and not kind of a laundry list of a bunch of different goods at once. It's something that you'll see in other countries. It almost looks like a copy and paste of every item you could possibly think of in the clothing category. We're going to say, as US attorneys, focus on the ones you actually sell, and because that's a requirement that the US has that a lot of other countries don't. And so, but while you're doing that for your core things, also start to think about the edges of everything. So set up that priority of start from the top, get the most important things protected first, and then spread out from there. And that includes international filings. That includes kind of extra things that you might not have as part of your core business, but do kind of still represent your brand. And there's, I think, a really good exercise of writing down everything you can think of that represents your brand, every logo, every design, your packaging, even like to a certain extent, kind of the phrases you use to describe everything. Get that all written down somewhere so that you kind of have this idea of what it is you might even be able to claim as a trademark, and then start to prioritize those of what's the most important thing when consumers see. And that's where you start. And especially you start in the US if you're a US company, and you start to work your way down from there.
Yeah. And one common mistake that we see is that folks will say, "Oh, I have a name, logo, and slogan, and I don't want to, pay a bunch of government fees, so I'm going to file it in one application." Again, because we're using the U.S. applications as a base everywhere else. A lot of times it can make a lot of sense to file names on their own, logos and names maybe together, then in a separate filing, and then a slogan in another filing. So you want to really think about as you identify all these things. These are not just one filing sometimes, and a lot of clients might push to do that because it's less expensive, but it's really not saving that much money, and it ends up becoming more costly as we go around the world because we could run into other issues with that. So just something to highlight there. Um, Eric, I'll let you continue.
Yeah, and so the United States has it does, in order to register a trademark as a US company, in 99.9% of cases, you have to be using the trademark in the US, meaning if it's products, it means products are in hands of consumers. You've sold products to a consumer or provided those services. And that is different from other places in the world. But what the US has created is a system called an intent to use application. You can say, I have a bona fide intent to use this application, so I want to reserve rights in it so that I don't get trademark squatters, I don't get competitors, or just happenstance, someone doesn't file something that while I've spent a year preparing my product, that someone else jumps in line ahead of me. And so an intent to use application can be really effective in getting the earliest possible rights in the United States, up to 3 to 4 years before you actually begin use of it, with extensions, and there's additional fees with those. But realistically, you want to get this filed as early as possible in the US, because you otherwise could get someone who jumps in line ahead of you if you wait. And that could cause, either, in some cases, it can be catastrophic. It could be that someone got in line ahead of you and now they have this presumed right that you, even if you used it before them and they filed before you, they could still have protection. And so it's important to get the trademarks filed as soon as possible.
Absolutely. So that's, a little bit of a really quick overview of the US side, and thank you for that, Eric. And if you've been to previous CLEs, we've got more information on US filings, so there's more content to dig in there. But as we're kind of getting into the international side, you say, okay, we've got all of our US filings made, and now we have to consider what do we do outside the US? The first thing to really note, and because this is a question we get all the time, is my US trademark registration valid in other parts of the world? The answer is no, never has been, never will. And the same goes for other, rights in other countries. You could have a registration in Europe, or you could have a registration in Australia, and it's not good here. So, trademark rights are just national in scope. So, it's very important to keep that in mind, especially as we're entering, into any kind of business that might implicate whether it's manufacturing or actually selling products or services outside the United States.
And Josh, I'll go into a quick, I'll tell more about this when we talk about enforcement, but we had a client who, tell the story further later. They applied in both the EU, in the US, they registered in the US, they applied in the EU, and then they applied in the UK. They got oppositions in the UK and in the EU by completely different parties with a similar name in different countries. And so even in the context of the UK and the EU now, there can be different parties within countries that you were once a part of, or at least the EU is kind of as a block, but the UK used to be a part of the EU. And even now you're getting different strategies from those different countries, which I think is just goes to show why it is very important to consider international protections.
Yeah, absolutely. And to Eric's point, there's not really a simple way to just get a registration globally. That's kind of the next question we get is, okay, if we can't use the US trademark, how do we get a global trademark? Well, no such thing as a global trademark. You still have to apply in each individual country that you want rights. There's a couple ways to do that, which I'll get into in a second. But that's the general idea is you got to come up with a list of countries that's important to your business or your client's business, and figure out what the appropriate budget will be, what you can spend, and then ultimately make filings. The one thing
Josh,
that we talk to clients.
So I don't know if we'll talk about this in the future, but one kind of keyword to avoid when you're looking at international filing is a filing service. Are companies that will offer to file your trademark in hundreds of different companies, but they're not lawyers. And so just be very careful of that kind of keyword as a international filing service. Could be implicating unauthorized practice of law. They could be kind of using records they're not supposed to, especially in the US. A non-attorney cannot file on behalf of a client. Only attorneys can. And the same is true in many other countries as well. So just kind of beware of the international filing service. Some of them are attorneys, but a lot of them are just services that are non-legal in nature.
Yeah. And that's why we have people here, Eric, to give them our our propaganda, so they'll have us help them with that. But that's true. Yeah, you got to be careful, especially in the international context. Lots of craziness in the trademark world. For clients that are reticent to attach budget to this process, the one thing we always remind people of is that we've helped a number of clients through acquisitions. When you're going through an acquisition, you're going to get asked what trademarks you own outside the US, because especially if you're getting acquired by an international company or a company that has the capability of taking your product or service and then selling it internationally, they want to know which countries or which jurisdictions they have the right to operate in that you have secured a registration in. And that is something that just becomes hypercritical and adds a lot of value. So even if it's going to cost, let's just say you put up $20,000 or $30,000 to get a whole bunch of countries filed and registered the trademark in, that can come back in droves should the company actually scale to get acquired. So that's one thing we always remind folks of, especially as Eric was talking about filing early, because we got an even higher increase in risk of squatters in other countries. If you think the U.S. is challenging, see what happens when you walk into Turkey or China and other places. You have squatters show up everywhere, and we have spent $10,000 or $20,000 in legal fees and sometimes a lot more to deal with a squatter. Whereas if we had just filed an application for a client in a particular country, it might have cost $2,000 or less. So, saving a few pennies up front, certainly going to cost a lot more later if the client runs into problems. And that's another reason it always sounds self-serving because we're like, file more. And that's obviously generating some business for us, but it actually generates less business for us in the long run because then we don't have to deal with all the squatters and all the litigation that comes from that, which is quite frankly a lot more lucrative for a law firm. So,
and I'll kind of piggyback on that and be the other voice of reason is that there is probably not within most companies' budgets to file in every single country that they could be selling products to. I think that from just everyone's got legal budgets and they're not unlimited. And so I think that there is a lot of really good strategy conversations to have about where to file that I think you can really maximize a budget in a way that makes a lot of sense by focusing in on kind of things that matter to the business. I don't think there's a one size fits all approach to, always file in this direction because it's so industry based and company based. But I'd also, on the other side of that, while protecting from squatters is super important, thinking too big is going to then almost cause paralysis because you're going to look at, well, it'll cost me, $100,000 to apply in all these different countries that I could apply for. So which ones do you choose? And it's going to depend on your business.
Yeah. And some of the questions we'll ask clients when they're making that decision is, A, where do you plan to sell your products or services? That's going to be a critical one. If you manufacture products in a particular country, getting it registered there could be critical too, so you don't have a problem getting goods out of the country from an exporting perspective. And then if there's a place where counterfeiting's rampant, and again, this would be your Chinas of the world, typically you want to register there. As far as budget goes, one of the things Eric and I have worked on with clients is we come up with, use the terminology tiers, but like we'll have tier 1, tier 2, and tier 3 countries. So we'll say, okay, for this client, tier 1, the most important jurisdictions we need are the UK, Europe, Australia, China, Japan, Korea. We'll come up with that list of 7 or 8 countries that for all their critical brands, or trademarks, whether it's the main name, the main slogan, stuff like that, we want everything registered in that country. And then we have tier 2 and tier 3, which are places that are nice to have if and when budget allows. So we can kind of come back to the client on a quarterly or yearly basis and say, look, we've got your trademarks registered in all your tier 1 countries. Now it'd be great if we could get some budget and go to tier 2 and tier 3, because these might be countries that you might expand to in 3 or 4 years, or a potential acquirer might find more interesting that you have the registrations in these countries. So I think to Eric's point, you certainly have to think about budget and what a particular client, and getting a client comfortable with that. And then just maybe scheduling it out and figuring out, okay, these are the critical ones we got to have. And then we go to the nice to have list and kind of see if we can ever get to that. And a lot of companies will eventually. I mean, especially if, I remember one time in December, we had a client who was like, hey, we they weren't in an acquisition footing yet. So they weren't trying to keep the books as pretty as they needed to. They wanted to actually reduce tax liability. So they wanted to spend money and get trademark filings made before the end of the year. So I think we went out and filed. I mean, it was a lot of trademark filings they made that year because they were just, they had the extra cash. They had a good year. So, worked out well for everybody. So get into the next question, which is the functionality of this. Like, how on earth do you file trademarks in other countries? Well, there's actually 2 ways. And the first way is we just file with a local attorney in that country. So if you're just filing in a couple countries, this is typically the best method. And also what we're going to talk about next is that there's something called the Madrid Protocol, which is an international filing scheme where basically you could submit one application to this international organization, and then all the countries that are members of the protocol, basically a treaty, they will accept that form of application and then examine it themselves. Well, that's great if they're members of the protocol, which some places are not. Like, go to the Middle East, a number of those countries aren't members of the Madrid Protocol, or you have, countries like Switzerland and random places like that that just aren't members. So you can either go and register using this sort of international system, or if you're just filing in a couple, if you're just filing in a couple countries, or the country is not a member of the Madrid Protocol, you're going to use a local counsel. A lot of trademark attorneys, this is very common. We just develop relationships with people around the world. So, for example, our firm, we've got a number of folks in Europe, a number of folks in the UK. I can think of an attorney in Mexico I'd probably talk to on a weekly basis. So we develop good relationships, and these local attorneys will take instructions from us. They will give us the local flavor. So let's say, hey guys, this is how you filed in the US. Here's some thoughts on the local, issues you might run into. They can help us run a local search using different, especially if it's a language that's different than English. They can help us see if there's any other problems in that country. So that's one way we do it, and it's essentially, for lack of a better way, sort of subcontracting out the work and then still managing that application for the client. A lot of the pros of this is that it certainly streamlines the process to file directly. You're not going through a system that then goes through the local trademark office. You're going right from a direct local counsel into making the filing. The other thing that's that you have to watch out for is that if you're making a filing with this Madrid Protocol system, it relies on the U.S. application and/or registration actually going through. So if something were to happen with the U.S. filing, you would actually run into a problem where you have to convert the Madrid application to what they call a national application. It's a whole process and a whole issue. So if you're filing with a local counsel, you have no dependency on that underlying U.S. application or registration. So it's a way to just kind of get away from that, especially if you think you have risk in the U.S. for some reason.
So Josh, another pro that I don't see on the slide, but I think is important, is the scope of filing in the foreign countries. If you go through local counsel, I mentioned kind of at the top of the program that the US, we recommend kind of tailoring the goods and services very specifically to what you're actually providing. But in other countries, that's not always the case. The strategy might be that you apply for computer software in general, where the US Patent and Trademark Office won't even let you say that. You have to say downloadable computer software for, and then say what the software is for. In other countries, you don't have to do that. You can just apply for computer software. And one of the benefits of going through local counsel is that they can advise, well, yeah, let's just file for computer software. Let's not file for your very specific computer software. So you can end up with rights that kind of more align with what other trademark rights look like in that country versus the Madrid Protocol, which we'll talk about, needs to be exactly the same as the US filing, which can be more narrow.
Yeah, absolutely. And then as far as the cons of using local counsel, look, it just gets more expensive, especially if you had 20 countries, it'd be much more expensive than the Madrid Protocol. And you've got to make sure that your local connections are reliable, because you're ultimately relying on them. And if they, for some reason, let you down, then that's obviously going to be an issue and something you got to solve for the client. So luckily, that tends not to be too much of an issue. But you just got to be careful who you choose to help you. As Eric mentioned, you can find a lot of craziness online. The relationships we have, they're vetted a lot, and there's something called the International Trademark Association, INTA, that so every year a lot of trademark attorneys get together from around the world, and typically the people that we know are there. Every once in a while, we also go to that conference too. So it's a way to make sure you know who you're working with. The Madrid Protocol is the one, and the sort of the fancy one that a lot of clients will find if they're searching online. And this we've been alluding to, which is it's an international system that from the United States, you can make this, you basically create this application, you submit it to the protocol, or what's called the World Intellectual Property Organization, which is the clearinghouse. Then all the countries that you select, you go through when you're filling out the application. It's as simple as check the box on each country you want to submit this application to. So you check all the boxes. You're paying a filing fee per country. So this is where budget becomes a problem, because people will say, oh, just go and select every country. Well, I think we did a quote once on, I think it was over $80,000 in filing fees or something crazy like that. So, look, to some companies that might be doable, right? But to a lot of clients, they're going to be like, absolutely not. So you have to kind of be, but it is simple as far as like once you draft the application, you're just literally clicking on the countries you want to get the mark registered in. And then essentially what happens is it goes to this clearinghouse. They have to approve it. Basically, they have standards that they're looking at. 9 times out of 10, it just gets approved. Every once in a while, they find something that you did in the US application that they want to fix, and then you fix it there. Then once WIPO, or the World Intellectual Property Organization, approves it, they then send it out to the individual countries, and the individual countries now review it based on their local rules and laws. So you could get an approval in 8 of the 10 countries you file in, and then 2 could find it's a problem. Like we, common places it's a problem that I'm always dealing with is China's going to come up again and again. We get some really strange refusals from there. Like we got one where it's like it's an immoral, trademark, and it had nothing to do. It wasn't immoral. If you look at it from a U.S. perspective, it wasn't even close to being anything offensive. It's just that they found that it could be considered offensive, or it could be of immoral, create an immoral thought or something like that, I think is what the refusal said. So you get some pretty crazy refusals, and you learn local trademark law pretty quickly the more of these that you file. And then, as far as the pros and cons here, it's certainly a lot less expensive. If I got 20 countries, it's going to save the client a lot of money to file through the system. And it's going to be arguably a lot less, upfront work, because like I said, it's one application and then click the buttons. The problems come back when these individual countries get a hold of the application, because a lot of times what will happen is they'll find some ticky-tack stuff that they want to fix. They'll say, oh, this language doesn't comply with our language locally, or like in China, you have you might have all these other crazy issues that come up. You still then have to hire a local attorney. So as U.S. counsel, we can't go into Korea or Japan or Europe, and we can't say, hey, all right, you found these issues, we'll fix it, and then we'll move on. We have to go hire that local attorney still. So it creates another layer of cost for the client that you need to prepare them for up front. You can't say, oh, this is just going to cost whatever, $5,000 between government and legal fees to file in these 7 countries. You have to prepare them for, well, if we get a refusal in any of these countries, we now need to hire a local counsel to get that problem fixed. Luckily, if you're working with a law firm, it doesn't have to be ours, although it'd be nice if it was. If you're working with a law firm that does this all the time, a lot of times we have relationships. So many times it's just a few $100s to fix the problem. It doesn't have to be thousands of dollars for each trademark. Sometimes it's going to be more expensive if there's a conflict or something like that. But a lot of times these ticky-tack things can be resolved. I will say I have noticed an increase in that sort of finding from these local jurisdictions. And I think part of it, my suspicion, although this is just a conspiracy theory, is that they're really trying to, throw an elbow, make a U.S. company pay a little bit of money to a local attorney, drum up some business there locally by finding some of these issues.
Well, Josh, there are some foreign attorneys I know on this call right now who will point to the fact that I think something around 98% of Madrid Protocol filings in the U.S. get an office action that then require a U.S. attorney to respond. So maybe
it
it's
goes both ways. Elbows get thrown both ways, right? Yeah. Sorry about that. But as a side note, in one of the all-time boons to business, the USPTO decided that you have to hire a U.S. licensed attorney to respond to an office action issued on a Madrid Protocol application filed into the U.S. from abroad. So people are forced to now hire folks with a law license in the U.S., although they do it with varying degrees of success depending on which lawyers they decide to hire. So that kind of concludes the how do you do this internationally. Are there any? I haven't seen any questions pop up in the chat before we get to the next section here. Looks like we got a lot of good information for the CLE credits, but I haven't seen any questions come in unless I'm missing them, Eric.
No, I'm pretty quiet in the question and answer. You can either answer them in the chat, or there's a kind of Zoom's got a question and answer section, so we're happy to address anything people send over. But I think that the next portion of this is really this idea of, okay, well, you own a registration in the US, perhaps in a few other countries, now what? And I think that's kind of the question that's a little bit tough. Okay, Josh, we did just get a question what other countries beyond the US and Mexico have an ongoing use requirement? I can answer this question because I just looked at it recently and I can't remember the other. So one is the Philippines has a declaration of use requirement. The other is, oh man, we just set up some There's at least one more. I forget which one it is. But a lot of countries, though, have a period where you must be using it within, usually it's either 3 years or 5 years, that even though you don't have to prove use, someone could file a non-use cancellation proceeding based on your non-use in that country. So while not every country has a proactive filing that you need to make, the Mexico, US, Philippines those are three that I know have them. Many countries have a system of either expungement or of cancellation if you don't use it in that country within a certain amount of time.
Yeah, and to Kevin's question here too. So most of the time when you get an internet registration in another country, the renewal is not due for 10 years. That seems to be a pretty common theme around the world. It's just that, yeah, these few countries like Mexico will say you still have to file something in, let's say, 3 years or 2 years to actually prove you're using the trademark, or else we're going to cancel it. The US has a similar thing at 5 years. So there, you have to be careful with that depending on
Josh, Cambodia is another one
yeah.
that has an ongoing use requirement. That was my our
And that's not
associate
one we see
Sophie
very often. Yeah, I
just
figured Sophie
messaged
would
me and
chime
said
in.
it's
Yeah.
Cambodia.
Yeah, there you go. So yeah, it's very few and far between you run into those, but you need to be aware of them, and yeah, certainly have to make filings there. Another good question just came in actually, Eric, which is when you file under Madrid, do they have a central database you could search before you file? The answer is yes. There is what they call a global brand database that you can search. It's a little clunky, but you can look at it, and it's, you know, helpful for finding things that are identical to what you're searching for. The challenge is that each individual country is still going to evaluate the trademark based on their local register. So let's say you're filing in China and there's a translated mark, you know, in Mandarin, or, you know, that would be conflicting. That's probably not going to show up in that WIPO search that you can do. So that it's okay and it's helpful. I'm not going to say don't try it or don't use it. If you, matter of fact, if you just Google, the easiest way to find it, maybe I'll find it and put the URL in the chat, but it's just Google like WIPO, WIPO trademark search, and it should come up like the global brand database or whatever. Click on that, and you could search by company name, by brand name. And again, it's not bad. I mean, it'll help you find things. But again, these it's not as good as going, like, let's say you want to file in the EU. It's you actually not only have the consideration of what's at the EU level, but then there could be all those individual countries still have trademark databases. So there's a lot of nuance to searching and clearing internationally. One of the reasons we're not really talking about today is how much, you know, I mean, quite frankly, the vast majority of clients are not going to take the time and money to search in all the countries they're going to file in. It's just going to be cost prohibitive, as opposed to sort of one of these more maybe AI branded kind of global searches just to see what's out there and type of thing. But they're not going to do like the deep dive most of the time. So, but no, it's a good question. Absolutely.
So Josh, I've got another good questions. They're coming in. Oh, sorry. Go ahead,
Oh,
Lacey.
coming in fast. And yeah.
That's okay. We had one in the chat. I just wanted to ask real quick, and it's about the 6-month deadline to get the benefit of the US filing date. There's a question for more explanation.
That's great. So we didn't talk about this because it gets a little bit into kind of the nuance of trademark filings. There is a magic 6 months that is a part of the Paris Convention. It's another treaty that a bunch of folks are signed into that says if you file in your home country, and I'm going to simplify this a little bit, but if you file in your home country, you have 6 months from filing to file in any other country who's a member of the Paris Convention and get your priority date as the date you applied in your home country. So there is, you can imagine a huge benefit in that, 5 months, right before that 6 months of filing, you get a free 6 months earlier as if you filed 6 months earlier, which is a huge benefit. And there's, I think we did an entire other presentation about ways you can kind of utilize that to do kind of fancy filings in different places. But one of the reasons why we don't kind of include it right now as a part of our core, like what we need to talk about, is that the US Patent and Trademark Office is taking right now almost exactly 6 months. For the last probably 4 or 5 years, it has been way over 6 months. And it is very difficult to counsel a client to say, hey, you should spend all this extra money in all these different countries when you don't know if it's been accepted in the US yet. And so a lot of the times our strategy was, yeah, get it accepted in the US, at least get it published with the US Patent and Trademark Office. And this was 10 years ago. And then we can really start, then's the time, to look at all the different things because we get the benefit. I think right now it's really difficult, especially with Madrid protocol filings, that if you get denied in the US, all of your Madrid protocol filings are affected. And you have to do, Josh mentioned a lot of fancy kind of filings to try to convert them and all this kind of things. And so it is a 6-month grace, kind of not grace period, but period that you can get the benefit of that. And so it's something your attorney will definitely talk to you about. But it is not something that I think is a primary driver of international filings like it used to be, because we put such an emphasis on the US registration being successful that we tend to kind of counsel clients like, well, you'll get a benefit, but it won't be as strong if you get denied in the US. Why does it matter if you get it in some other countries? But there's definitely a lot of strategy that goes into that.
Yeah. And then last question, we should move on because we got about 20 minutes left and we have a lot more slides than are going to fit in that 20 minutes. But Greg asked a great question. So how do you assist clients in M&A due diligence to assure that foreign trademarks aren't going to be lost or challenged due to non-use? Well, at the end of the day, if you're not using it, you're going to be subject to these non-use challenges if they come up. In our experience, it's rare to get them. We've had marks that have been registered in countries for a very long time and clients weren't in those countries yet and they did not get non-use challenges. So certainly if there was a nefarious person out there or somebody targeting the company, that would be a big problem. Most of the time, these things are not, that country, they're flying under the radar for the most part. But yeah, it's a problem. And I mean, one of the things is to telling the client, look, if you have the ability to get some use underway in these critical jurisdictions that you think are going to be really important in an acquisition, then get it started so we can, if we have a challenge, we can show that there's use in that market. And yeah,
I think the bigger challenge there, Josh, is actually even knowing that a client has those applications to begin with. I think that is a bigger M&A challenge of clients not knowing what marks their attorneys filed. And so great record keeping is obviously going to help with that, asking the right questions. And then also there are vendors that will, Core Search for is one of them, that you can spend a good amount of money to have them search every available database for ownership matches, things like that. There are ways to do it. There's platforms that we use that will monitor some jurisdictions, and so keeping an eye on it, I think, is even more important to make sure you get your renewals in, things like that. But I agree with Josh. I think it's going to be difficult to counsel a client to tell them to use it somewhere to avoid a non-use, but it's more important just know they even have it there to begin with.
Yeah. And it's funny. People might say, how do companies lose track of their trademarks? You would be surprised. I'm even talking to somebody now who, they're basically like, yeah, we've had all these trademarks. We know we've lost some, we don't, the last law firm didn't do a good job of telling us what was coming up for renewal. So we're getting engaged to go look everywhere and find registrations that not only have, but have let abandon, and then try to figure out how to fix everything. So you have an ownership, you have a leadership change at a company, or you have a law firm that just, stopped caring about a client for some reason, which unfortunately seems to happen. You'd be surprised. People really don't know sometimes what they have registered, and it's shocking, but happens. Well, Eric, these have been great questions, but I'll let you kind of talk a little bit about enforcement so we at least get through some of this before we get to the last, a little bit.
I think it's the other side of the coin, right? What's the point of owning a registration if you are not able to actively enforce it and protect a trademark? And so I think when it comes to a kind of global monitoring, it can be extremely difficult because of exactly what we talked about. There's marketplaces everywhere. There's growing marketplaces that are country specific. So you look at the, like Mercados, all these different websites that are catering to only very specific countries. And it becomes really difficult to kind of figure out what to prioritize. And then in some cases, there might be a situation in which you have your trademark in the US, someone else owns a similar one in Canada, someone else owns it in Mexico, someone else owns it in Europe, and you're kind of just stuck making it work. And so to avoid that, it really comes down to knowing your marketplace very well and knowing your marketplace on a global scale, because you're going to be, the trademark owner is going to be the first line of defense more so than any kind of lawyer is going to be. The owner themselves is going to know who the major players are, who's coming up, who's using certain names that they should be aware of. And so Google Alerts, a great way to kind of just get a kind of almost too broad, sometimes scattershot of everyone who's using a certain name. Be connected on social media, making sure to kind of understand, what to prioritize and what to not. So, for example, I say this kind of as a real world scenario. I received a list from a client of, I think it was about 120 counterfeit listings that they found for their product. And some of them were very much either eBay. There were some that were on Amazon, Walmart, of this third-party sellers that popped up. But then there were all these websites that I was like, what in the world is that? And it was, like a Russian website. And then there's like a Singapore website, and all these different listings that they just went deep on. And I basically did the same thing we did for others. I said, okay, let's put these into tiers, because I'm going to spend if I start with the ones that are in all these other countries, it's going to be very difficult, because do we own rights in that country? And then you start to go down that route of, do I need to hire a Russian attorney to attempt to get the Russian website down? Can you even do that in certain circumstances? And so I think that while you might see a lot of infringement out there, it's still important to inform clients of which ones to prioritize. And US rights are going to be at the top of that priority, but you can't ignore things that are going on in other countries, especially when there's potential not counterfeits, but just infringement. And so an example, I work a lot in the board game space, and which is one of these countries that have a very heavy European. Germans love board games. It is like the national pastime of a lot of German families is playing board games. And so, but there are then circumstances where there are certain games that have different names in different parts of Europe, because the name is registered in Germany. Another person owned a similar trademark in Spain. And so you have, even in that marketplace, it very much split up. One of the examples in the US is that Hellman's mayonnaise, is called something different west of the Mississippi than it is east of the Mississippi. And it's one of those weird facts that I remember reading on the back of a packaging, 25 years ago. And that's still the case. If you don't enforce your rights and get a good idea of kind of what's already out there, then people can either box you out of certain countries or make it very difficult for you to operate, even if you are primarily focused in the US. So it's important to know who's out there, but I think it's also, you're not going to be able to go after every single user of a trademark, and it's just a matter of kind of managing that risk.
Yeah, and the last point I'll make here is there are some good software solutions for this these days. If you follow me on social media, I rail against AI a little bit, but there's some kind of AI-ish tools out there that are helpful. So we have a software that'll help us monitor a pretty good amount of countries, and they kind of continue to expand. But if a trademark gets filed somewhere and it's similar to your clients, you can get an alert through these software tools, and that's very helpful, because you can keep an eye for clients and say, look, all these trademarks are getting filed, and typically companies that are more serious threats from a monitoring, that are not counterfeits, they're going to be the ones filing trademarks because they're more legitimate businesses. And if they develop a legitimate business within a zone you need to expand to or around you, they could actually cause a narrowing of your rights. So those tend to be some of the more interesting cases we work on. And then there are software tools that will monitor for all these counterfeit or other listings out there that you can use. Word to the wise there is that they also offer like takedown services through these tools, which we have counseled clients not to use, because if you inappropriately take something down, that can give rise to liability as well. So, but anyhow, there's some software options out there for monitoring that, depending on the size of the client and depending on, what they're trying to do, you could certainly use those tools, and they could be pretty helpful. As well. Yeah.
And to go back to the example I alluded to earlier, we have a situation in which a client registered their trademark in the US, and then they got a ping that congratulated them for some funding that they got, and it was not them. It was another country with an identical name in the UK. And so client said, well, we have to do something about this. There's confusion happening right now. And so we looked, and we were not sure was only in the UK or not, or if they had US clients, if they had European clients. And so the client had not done any foreign filings. And so we said, all right, let's start with the UK and EU, at least get something in there because you have had UK and EU clients for several years. This makes a lot of sense. And so we filed this. And then, as I mentioned, we got 2 different oppositions from 2 different parties, neither of which were the party that we were actually concerned with, who had started a similar name in the UK. And neither of them were the trademark owners that reached out to us and said, hey, you're infringing on our trademark. And we're able to work out both of them, and it's working out fine. But just the idea that there could be, I just thought that was incredible that we got oppositions from 2 different parties, neither of which were the party we were concerned with. And so I think that just is a very unusual example, but a clear one that there is a lot of competition out there. Yeah. And so what we had to do is we first had to determine what are the risks here, because clearly we used it in the United States before they did, and there was no question in my mind that we had used it first in the United States, but our client did. So then the next question is, well, did we use it first in the UK? And that was one that was harder, because to try to narrow down when did they begin use in which country is even harder than anything else. And then you have to figure out how long have they been using it. And then is the question, do we want to coexist with them, or do we want them to stop using it? And could they come back and then say, well, no, actually, you're an infringer here in the UK or in some country where I've already established rights? And so it can be a huge risk management problem to not put the client in a situation where you send a cease and desist letter and suddenly you get a nasty grant back that says, no, actually, you're infringing on my rights in my country. And so it's very kind of difficult and challenging, but very worthwhile to make sure to do that kind of analysis.
Yeah. And I mean, to Eric's point here, a couple of things actually, but one, and I have it on this slide here, which is on the bottom left-hand corner, which is what type of ask is appropriate in a situation. A lot of trademark enforcement is not necessarily black and white. It doesn't mean that one party has to stop using the mark. There can be different limitations that you put on a party that might be using a similar but not identical mark. And there could be trade channel restrictions. There could be different things that you agree to. And so that's why we typically say that enforcement's always going to, start with a demand letter. And there's a lot of ways to keep folks out of court, but ultimately, obviously, lawsuits are an issue. The one thing to highlight, and this is a great practice tip, is that tell your clients to keep good business records. It is surprising how poor a job clients do of keeping business records to identify when they've started offering particular goods and services in which country, especially because they might lose that data at some point because they didn't think that they might need to keep it. And so, especially if that use, you have to go back several years or more, and all of a sudden they don't have it. Now you have no evidence, that's available to you to help prove a case. That's a huge issue. So just something there. And we've kind of covered this slide, so I'm going to move on. Eric, I don't know, you want to talk real quick about customs?
Yeah, well, this is Customs and Border Patrol is a tool that's available to anyone with a registered trademark or registered copyright. It's very underused. I think I looked last and there was something like 60,000 brands that were registered with Customs. Essentially, what they will do is for a pretty small fee, I believe it's somewhere $200,
like
something like that.
Yeah.
They will put your information in their database that they will reference when they are looking at incoming, when they do a customs examination. Even to the point where you can actually provide them a webinar or a training that they will put into their rotation to how to identify counterfeit goods. And so if you are dealing with especially luxury goods, you need to be on this database. They will contact you if they think they found something, and you can post a bond to have them hold it until you get a chance to examine it. But yeah, we have luckily the only time that we have ever gotten any kind of pings for one of our clients was they had switched manufacturers and distributors, and so that suddenly all these were coming in through a non-whitelisted distributor that we got it cleared up. So but it can be very helpful, and there's been a lot of success stories with stopping counterfeits from coming in through Customs and Border Patrol.
Yeah, I'm always surprised it works, to be honest with you, because it seems like it's a crazy thing for them to actually catch and how much they're bringing into the country, but they do catch it, and so it is something that's helpful. The last portion here, and please, if you have any other questions, got about 9 minutes left, so now's the time to get those questions in, please, in the chat or in the question and answers section there. And this was actually brought up in a previous question, but how do you the maintenance of these things? It seems simple, but you would be surprised how many people don't do it correctly, or let it go because they don't have a trademark counsel monitoring things they've already filed, or even in worst case scenarios, they have trademark counsel, but they're not paying close enough attention. Trademark renewals are due so infrequently, people forget about it. If you have a renewal due on, if you have an LLC and you have to pay the maintenance fee every year, you're like, okay, every September I got to do this, or every October I got to do that. And as a business owner myself, like, I have a clock in my head. Every month I know there's certain things that are due this year. Like, in July, this insurance payment's got to happen, or this insurance renewal's got to be done, and so on and so forth. So because these renewals are so infrequent, people forget about them. In the US, you got after 5 years of registration, there's essentially a renewal due. And then after 10 years, another renewal. And then every 10 years after that. As we mentioned earlier, internationally, most of the time it's 10 years, which is a crazy amount. You think about what happens in a decade and how many people come and go in a business or a law firm. So there's a lot that can happen and a lot that can get lost. And there are certain countries, like we mentioned, Mexico, Philippines, and Cambodia, that have actual requirements sooner than that 10 years, typically around 2 or 3 years, to prove that you actually have use, or you'll lose it as registration. So these are things that once the work's been done, again, it's one of those things that seems simple, but somebody's got to be doing it, and somebody's got to be paying attention to it just because of how infrequent it is. So I don't have any questions, which, we had great questions there for a moment, and then everybody kind of, I don't know if we lulled them to sleep, Eric, or what happened.
I think we've just so comprehensively answered all of these questions, this topic, that they're like, well, I have no questions. I think even to your point, Josh, you were saying that it's a 5-year renewal. To further confuse everyone, the renewal window opens at 5 years. So you actually have 6 years to do it. And that is completely foreign to a lot of folks, of this idea of, like, there's a 6-year and then a 10-year. And then if you own a Madrid protocol filing, you also have to renew the Madrid filing every 10 years from when you initially file it. And so there's a lot of deadlines that can be very easy to miss. And so making sure to keep very good records for your clients is very important.
Yeah. And we'll do one thing really quickly, because I think it's such a fun story. But did you know there's 2 Budweisers? And this is a great example. These companies have been litigating for like over 100 years about who can use Budweiser and in which country. So there's a Czech Budweiser, claims to be founded in 1895. And then in 1876, we have the US Budweiser. And of course, back in the 1800s, we didn't have the internet, and it was a lot harder to register trademarks in other countries. So the US Budweiser didn't get around to it. The Czech Budweiser's over in Europe registering things. And if you have interest on this, you could always look up this online. But it's a fascinating case where in a number of countries, Anheuser-Busch has to call its beer a Bud and not Budweiser, because this Czech company actually owns the trademark for Budweiser. And in so yeah, and you can see here, we've got a little bit of information about it. I think it's the UK where they actually have, the UK found after some litigation, they could both coexist and offer Budweiser, which is wild. So if you're over in the UK, you can look for 2 different versions of Budweiser, one being the Czech version and one being the US version, which is kind of wild. But this is, even the largest companies in the world have this problem, and it's can be very difficult to solve, as they've been, literally litigating for like better part of 100 years over it. Conclusion, got to start with your US marks. If you don't have a good filing, think of it as your foundation. You don't have a good foundation, the rest of the world's going to be a hot mess. File early. Make sure you consistently audit your portfolio. You'll also be surprised how many clients register a couple trademarks, forget about trademarks, have all these other brands they're creating, don't file anything. Got to always look for that. Look for gaps in protection where clients start expanding the goods and service offering that might not have been included in original filings. So you need to go back and make another filing there. Get the foreign filings in as soon as budget's going to allow. It helps prevent squatters. Then you've got to actively police and monitor. So
we've got a couple of minutes. We got some questions come in. Josh, does it, for Madrid protocol, does it matter if it's on the principal or supplemental register?
Yeah, I'm pretty sure it has to be on the principal register.
I think that as long as it starts on the principal register, I believe it can still be a basis in other countries, but other countries are way more
that's what I was
strict
going to
about
say.
descriptiveness. So it could
If
be
we
the
have
basis of it, but it's going to be very challenging to get it
if
registered anywhere else.
if we have something we think is descriptive in the US, what I typically tell the client is if you want to file another country, we've got to have like a logo with it. We've got to have some design element, with which not just a font, but like an actual like design of some kind with it. And then we file that combined mark with the name and the logo in the foreign countries, because you're almost, if you think that there's a descriptive, if you could smell a descriptiveness issue in the US, it's going to be denied just about everywhere else in the world. So they have a lot less patience for that stuff in other countries than we do here. Which is actually, that's one of the positives. I like that about other countries. I think that people should create more creative brands, and the fact that we let people register uncreative brands in the United States is always a little bit of a head scratcher to me.
Final thing, someone asked, if you're unsure where a business should expand, what are the top countries? I'm going to use the lawyer answer of it depends. Typically, a lot of the countries or the companies we work with are English. They're targeting English speaking countries or Western countries. And so the ones we see the most are Canada, Mexico, EU, UK, and then China. And I think, Josh, you mentioned a couple of these: Japan, Korea, Australia. Those tend to be the ones that are the most frequent, but that can change wildly because certain industries are going to be very focused in South America, Central America, especially products that tend to get imported south rather than across the Atlantic. Those tend to be kind of ones that you want to focus on, just depending on what the needs are of the industry.